This lecture will be on the U.S. Constitution, and directly after, we will go over the Nevada Constitution. Um, Lots of information in this, and hopefully, you have read the chapter on the U.S. Constitution by now and the pages that were assigned to you in the Battleborn Reader, the PDF that is on Canvas. And also, hopefully, if you haven't, you can pause and get out the back of your book where the Constitution is. And when we get to the part of going through the Constitution, you might want to follow along in the Constitution. Okay, so today's objectives are to talk about three federal documents: the Declaration of Independence, Articles of Confederation, and the Constitution, as well as the arguments around the Constitution and the amending of the Constitution. And then at the end, we will talk about the Nevada Constitution and see how they compare to each other. So, what is the Constitution? It's kind of like our owner's manual or the rule book for American government. So, the Constitution tells us how to set up government, what the rules are for changing it, how to organize our political life. But mostly, it's a statement of our fundamental principles in the way we wish to be governed. And it kind of takes the 7 ideas, the American ideas that we talked about, and puts them into law and institutionalizes them. So, because this isn't a history course, we won't spend a whole lot of time on the history around making the Constitution, but please read that in the chapter. But just know that at that time in the 18th century, there were no other nations that had anything like an American Constitution. So this was a new experiment for the framers. The colonial politics wanted to become a new nation and have their own constitution because of a variety of reasons. One, the distance from the British authority, the fact that they didn't have any representation, um, the ability to rise in social mobility was difficult without their own governance. They were already making covenants, promises amongst themselves, and they were conflicting with the laws of Great Britain. They yearned for stronger individual rights. They were having border conflicts with various other nations, as well as the Native Americans, and they were being taxed by the British Crown. So many taxes that here's just to name a few. There was a sugar tax, the stamp tax, the quartering act, which said that they had to quarter soldiers, British soldiers, within their house and feed them and give them room and board. So it's somewhat of a tax. The Tea Act, the Boston Tea Party, and all kinds of coercive acts. All of those did not lead to a revolution until the late 1770s, mid 1770s. So around that time, to be exact, July 4th, 1776, everybody should know that date, is when the leaders, the framers of the Constitution got together. They were the leaders of the other colonies, and they decided to um, write the Declaration of Independence, which was basically a statement. It had two parts. The first was a statement of principles, and the second part was their list of complaints of the British Crown. This famously opens with all people, we hold these truths to be self-evident. They listed that people are equal, that they have certain rights that can't be taken away from them. Among these are life, liberty, and the pursuit of happiness, and that people form governments to protect those rights. And that most important, which we often forget, is that governments derive their powers from the consent of the governed. So that we put together a constitution, we as people say we are giving you our consent to govern us, but it's based on the power coming from the people. And then the list of grievances were the violations of their right of representation. They lost the independent court, and the maintenance of a standing British army within the colonies. They didn't like that. There is a great HBO program called, oh, sorry. Okay. I'll put the new link in here, called John Adams, and there's a nice scene in there where they read the Declaration of Independence. I will change that YouTube link to the new one. All right. Within the Declaration of Independence, there are places that talk about these 7 ideas that we just studied in the first chapter. So you will be asked a question on your exam to write about one or two of these ideas. So you might want to look at the Declaration of Independence and what it says here on the ones that you pick to choose to write on in your exam. So the articles, that was the Declaration of Independence. Shortly after the Declaration of Independence, the colonies decided to get together and make an alliance of their independent states and make their first attempt at a constitution, which was called the Articles of Confederation. It didn't last very long, it lasted about 6 years. It gave the states the rights to set up their elections. It gave the states the right to decide who got to vote. At the time, it was land owning white males in most places. It also gave the states the ability to have their legislative deliberations in public if they wanted to. A lot of people could vote at the town hall meetings, meaning land owning white male. The national government was quite weak underneath the Articles of Confederation. They were very dependent on the states. They had no executive branch. They didn't have the right to tax, and therefore were unable to have an army, and that made it difficult for them to do their job of protecting from foreign powers. You can take a peek at this video. This is from Alexander Hamilton. The number is Yorktown. It's right after the Revolution, and during this time when they're trying to come together as united colonies. So the successes of the Articles of Confederation are that the power remained close to the people. So within the states, they had a lot of power. The problems were, like I said, Congress had no ability to raise any taxes and therefore no money to have any kind of military, and they were unable to stand up to foreign powers. So, hence, they needed to do a redo and make a constitution. So they came together for a couple months, starting in May, and they discussed the various problems. There are 6 arguments that they struggled with that your book outlines, and we'll go over them now, but please pay attention to the third one primarily. That one will be on the exam. The first challenge that they had was trying to figure out how much power should they give the common people. They decided they would do it through elected officials, so they would let people vote for their representatives. But who would they vote for? Would they vote for the House of Representatives and the Senate and the President, or would in the original contract, they said that people could only vote for the House of Representatives. And these representatives in turn would make policies, and they would also so the House of Representatives would select the senators, and then the senators and House of Representatives would select the president. In the original Constitution, that's the way it was laid out. But over time, citizens won more power to vote, and this happened through the amendments. They were able to elect a president through the Electoral College. Eventually, they were able to vote for senators. African Americans, male African Americans, got the right to vote, as did citizens, and then women in 1920, and then 18-year-olds won the right to vote in 1971. But this is in bold here. That means it'll probably be on the exam. So in the original Constitution, the only office that people could vote for was the House of Representatives. And then after the amendments, we were able to vote for the other offices. The second challenge or argument was deciding how much power the federal government should have and how much power the state government should have. So they came to a compromise on a system that included both national and state power. The federal government took over many functions of government, but according to Madison, it was not quite enough. The state government, they kept many of their duties, but as far as state advocates, they felt like it wasn't enough. But the system that they came up with is a mixed system with a strong national government that nevertheless leaves considerable power to the state governments. This is called federalism, and our next lecture will be on federalism. We'll talk a little bit more about the challenges of the federal government having certain power and the state government having certain power. The third challenge that they had, and this one you will be writing on your exam about, so please pay attention, is deciding how many representatives would come from each state. There were very populated states like the state of Virginia, and then less populated states like the state of New Jersey. So we had big states and small states. And Virginia offered their plan. They said, hey, let's have two chambers, bicameral, and bicameral means two chambers, bi meaning two cameral chambers. And let's make it, let's say that the citizens vote for the House of Representatives and the House of Representatives will vote for the Senate. And let's say that all of these representatives will be based on population. So, for example, if Virginia had the most people, they would have the most representatives in both the House of Representatives and the Senate. And New Jersey said, oh, no, 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 you're not grabbing all that power. We think that it should be just one chamber, a unicameral Congress, and that each state should just have one vote, one representative. So that would mean that the small states would have the exact amount of power as the larger states with many more people in it. So they came to a compromise, and it's called the Connecticut Compromise, and that they would have a bicameral Congress, which is what we have now, which is the House of Representatives and the Senate. The House would be based on population, and the Senate would be equal representation, meaning two representatives for each state. As we go forward, you will need to know these numbers. So if there are two representatives for 50 states in the Senate, that means we have how many? 100 senators. The House of Representatives is based on population, and the number has been cut off a while back at the number of 435. So we have 435 in the House of Representatives and 100 in the Senate. Let's just clarify some terms. So Congress is both the House and the Senate. Oftentimes you'll hear in the news people will refer to the House of Representatives as Congress. They are a part of Congress, but so is the Senate. So just remember that the House of Representatives is based on representation by population, and the Senate is based with two people per state. Now, the House of Representatives are responsible only to the people in their district. For example, the state of Nevada has 4 House of Representatives. If you live in District 1, your representative in District 1 is only accountable to you and your district, not the whole people of the state of Nevada. However, the Senate, we have 2 senators, Catherine Cortez Masto and Jackie Rosen. They are both accountable to everyone in the state. So if you want to know who you need to contact either your district representative or your 2 senators, which would be the same for everyone else in the state. All right, the fourth problem that came up with the framers was deciding about the presidency. They weren't sure if they even wanted to have an individual do it. Maybe they would have a committee. Many of them feared that a president would gain too much power and start to look like the monarchy that they just fled from. So many delegates worried that a single executive would grow too powerful and become, as Governor Randolph put it, the foetus of monarchy, the birth of a monarchy. So there was a lot of back and forth on this, and they finally said, let's have it an elected position for 4 years, and we'll permit them to go up for re-election too. There were no term limits on the presidency in the original Constitution. That came later in an amendment after FDR died in his fourth term of office. They finally put a 2-term limit to presidents. The Electoral College is also was also a way of electing. Originally, like I just said, we elected, or citizens elected, the House of Representatives, who elected the senators, and the senators and the House of Representatives elected the president through what was called an Electoral College. That changed now to, instead of the legislature electing them, we have electors in the state. So this was another compromise, that each state would have the same electors as it had members of Congress. So they wouldn't be the same people, but it would be the same number. For example, Nevada has 4 House of Representatives and 2 senators. Therefore, we have 6 electoral votes. 6 electors who make the electoral vote, which we'll talk about in a minute. Yes, this is a map showing each state how many electors they have. So, for example, in California, there are 2 senators and 53 House of Representatives. Therefore, they have 55 electors to vote in the Electoral College. The 5th problem is the separation of powers, or challenge. So the framers made 3 branches of government: the executive branch, which held the presidency and all of the bureaucracies, the legislative branch, which was Congress, and the judicial branch, which were the courts, and gave them each powers. So the president, Congress can pass legislation, but the president needs to sign it, or the president can veto it. Congress over the president. The president is the commander in chief, but the Constitution gives Congress the power to declare war and set the military's budget. Congress can override a veto by 3/3 vote in both chambers. The president can negotiate treaties, but the Senate must ratify it by a supermajority, 2/3 vote. Anything over 51% is a supermajority. So a lot of these challenges, the framers decided on supermajorities. The president appoints ministers and the Supreme Court justices, but Congress must approve them. Congress has the ultimate power over the federal officers. The House has the power to impeach, which means formally accuse the president or any other high officers. And the Senate has the power to try that impeachment. And then the court has power over both Congress and the president by striking down any laws that Congress makes or that the president makes that violates, or any acts that they do that violates the Constitution. And it kind of looks like this, and I would make myself familiar with the separation of powers and checks and balances. There will be a question on the exam about that, just making sure you understand what it means. The 6th challenge is the principle we are most ashamed of, and this is the principle of slavery. Slavery is mentioned 3 times in the Constitution without ever mentioning the word slavery or slaves. I've listed them down here below so we can go over them. The men and women in bondage were a great source of wealth wealth and power for many of the states, especially Georgia, South Carolina, and Virginia. At the Constitutional Convention, they faced a very strong problem. They wanted the South wanted to protect slavery, but the North and all of them still wanted to form a union. So they had to figure out how they could negotiate a couple of the problems. The first one being how to count the representation. If the House of Representatives was to be based on population, the large slave states didn't want to have less representatives, so they wanted to make sure that their slaves were counted, but they didn't want them to be counted as a whole person because they weren't treated as a whole person, and they came up with some random fraction of a number, 3/5. And you can see in the, let's see, it says, this over just a little bit. Representatives and direct taxes shall be apportioned among the several states which may be included within this union according to the respective numbers, which shall be determined by adding to the whole numbers of free persons, including those bound to service for a term of years. So that would be people who are working, uh, maybe even, I don't know, maybe even prisoners at the time, and excluding Indians not taxed, and 3/5 of all other persons. So they basically called slaves all other persons. So that was for the basis of representation. Let me just move to the next slide so it makes a little more sense. If you look at the state of Virginia at the time, like 750,000 people, nearly 300,000 of them were slaves. So that's about 40% of their population. So they were very strong advocates for counting the slaves as well so they could have more representatives in the House of Representatives. And then there were some states like Massachusetts had no slavery, very little in New Hampshire and Pennsylvania, Connecticut. Okay, going back to that was one clause in the Constitution. The second one was about the trade, slave trade. And same thing here. The people who wanted to do away with slavery knew that they needed the people to sign on to the union. And so they made a compromise and said, we will not, let's see if we can find it up here. The migration or importation of such persons as any of the states now existing shall think proper to admit shall not be prohibited by Congress prior to the year 1808. So they gave themselves a 20-year window. And when I'm in my face-to-face class, I usually ask them why they think that. I think my guess is that they probably thought many of them weren't going to even be around in 20 years. So 20 years brought it to 1808, but we know that slavery wasn't abolished until after the Civil War, a good 50, 60 years later. So it wasn't like the people that were anti-slavery got right on it right when that 20-year expired, but it was in the Constitution there. The third clause of shame that we have is that if fugitive slaves are found in a free state, they must be returned to their state, to the slave state. So that can be found in this section here. Yes. All right. So the preamble of the Constitution is very important. It's a very elegant opening sentence. Starting out with "we the people." So we the people of the United States. So it's not this government is doing this. It's we the people are giving the right to the government we're giving our consent for them to govern us. And these are the things that we want the government to do. We want them to establish justice. We want them to ensure domestic tranquility. We want to provide for a common defense. Promote general welfare, and secure the blessings of liberty to ourselves and our posterity, our children, our next generations. Do ordain and establish the Constitution of the United States. Beautiful opening sentence. Beautiful goals to strive for. And remember, this whole idea of the United States of America was an experiment that hadn't been done before. Okay, so from here on, if you haven't already, please open your books to the backs, or if you have a handy small pocket Constitution, which I recommend everyone should have these days, so you can look things up. It's not a very long document. It's only a dozen pages or so. Go ahead and refer to this. We are going to go through it, but I don't have this written on the slides, but you do need to know that the original Constitution has 7 articles in it. So we will go over the 7 articles and generally speak what's in it. And then after the Constitution was ratified, then we had we quickly passed the Bill of Rights, the first 10 amendments, and then after that, we have passed 17 additional amendments. So there are 7 articles to the Constitution and 27 amendments. Keep that in mind. So the first article is the longest in the Constitution, and it describes what Congress should do. So this is about the legislative branch. The first article sets up the legislative branch. The second section establishes the House of Representatives, how they should be voted for, how long they should serve. The third section establishes the Senate. And then the most important section that I'd like you to remember is Article 1, Section 8. We will refer back to this several times. Article 1, Section 8 is the most important passage in Article 1. It tells Congress what it can do, and it gives some examples that they can lay and collect taxes, they can declare war, they regulate interstate commerce, they can coin money or make money, print money, and raise an army. In the final paragraph, there's also what's called the Necessary and Proper Clause. You need to know this as well. And the Necessary and Proper Clause says near the end, so this lists all the things that Congress can do. They can borrow money, make post office and post roads. They can set up inferior courts to the Supreme Court. They can provide for a navy. At the end, it says, and they can make all laws which shall be necessary and proper, for carrying into execution the foregoing powers and all other powers vested by this Constitution in the government of the United States or in any department or officer thereof. So basically, what it's saying is that the Necessary and Proper Clause has a nickname. It's called the Elastic Clause. And it's basically saying we've listed all the things that Congress can do, but there may be some things that we're not sure of or that we didn't think of. Or, for example, 240 years ago, they probably never imagined we would have a way to communicate by the internet, and that the internet may be a public good that people should be able to use, and that it probably needs to be regulated by the government. That would be something that might be considered necessary and proper for Congress to make laws on, but that the founding fathers could no way have thought of and listed out in the list of this section. So the Necessary and Proper Clause allows for things that they haven't thought of yet, or that might become necessary and proper. And then Section 9, it says what Congress can't do. Habeas corpus means that the government cannot hold prisoners without formally charging them of a crime. And then there's also the Emoluments Clause there. We can look at that. Maybe some of you have heard that being talked about in the news lately. But the Emoluments Clause says, no title of nobility shall be granted by the United States, and no person holding any office of profit or trust under them shall, without the consent of Congress, accept of any present emolument, office, or title. So when someone is in office, for example, the president or any judges or the vice president, they cannot accept money through their businesses. They cannot profit off of while they are in office. And so they can't, from foreign dignitaries, they can't become a king of another country. They can't receive payment for hotel rooms or sell their products of a company that they own, or receive any kind of gifts, which includes bribery or anything like that. That's the Emoluments Clause. We'll talk a little bit more about that when we talk about the presidency. All right, and Article 2 is the article that sets up the executive branch. The president must be a natural-born American, at least 35 years old, who is chosen by the electors for 4 terms. Each state decides who elects the electors, and whether it's a winner-takes-all or proportional representation. Most states do winner-takes-all, so whoever wins the popular vote, 51% of the popular vote in that state, all those electors' votes go to that candidate. I'll explain a little bit of that in a minute. The Constitution says that the executive power is vested in the president, so he executes the laws through the bureaucracies. Section 4 allows for removing a president on impeachment for the conviction of treason, bribery, and other high crimes and misdemeanors. Some of these high crimes and misdemeanors during that time are they can be defined by Congress, but during the time that the framers wrote the Constitution, they were considered anything that is the abuse of the power of the presidency, its office. Um, now four presidents have faced formal impeachment proceedings. We have one current president now facing impeachment proceedings, although only one, Richard Nixon, was forced to resign from office. He did not go to an impeachment trial with the Senate um, because he resigned. He knew better. Okay, so if we look at the breakdown, this shows kind of proportionally how these states, it's not their actual size, but their electoral size. So Nevada is a very large land-wise state, but as far as proportionally, we only have 6 electoral votes. So proportionally, this is what the map looks like. All right, there's a couple of videos you can watch. I've selected this one. You can watch this one too. This one's done by TED Talk. The one I've chosen is done by, done by CNN. We'll watch this one today. I'm going to go, I won't always play it for you in the lecture, but I think I will this one because the Electoral College is going to take some time for it to completely sink in, and I think this one describes it pretty well.
Americans do not vote directly for their president. I'm not talking about a government conspiracy. I'm talking about the Electoral College, a system that has been around since the birth of our nation. What is the Electoral College? The Electoral College is not a building or institution. It's just the name given to a designated group of people who cast each state's official votes for president. This group is made up of 538 people. Each state has a different number of electors based on their representatives in Congress. So, states like California and Texas have more votes than states like North and South Dakota. The only exception? The District of Columbia, which has 3 electors, despite not having any voting members in Congress. How does it work? Each party selects their own group of electors. Each state then empowers the electors who represent the candidate who won the most votes, except Nebraska and Maine, who award electors based on a combination of statewide results and districts won. The candidate who receives at least 270 Electoral College votes becomes the next president. What if there's a tie? If there is a tie, or if somebody doesn't get to 270, the House of Representatives appoints the president, and the Senate chooses the vice president. Why does this system exist? In short, the Electoral College was created as a compromise of several different proposals by the nation's founders. Critics say the system allows candidates to become president without necessarily securing a majority of voters' support, which happened in 2000. Advocates argue it ensures less populated states aren't completely ignored. How are these people selected? The electors are chosen by their political parties in each state. The only rule is that they cannot currently hold office. Can an elector ignore the popular vote? Yes. It's called a faithless elector, but it's rare, and it has never affected the outcome of an election. Some states require formal pledges enforced by fines and possible jail time. But, historically speaking, members rarely depart from the will of the people.
Okay. So, this usually in a live face-to-face class brings up a lot of discussion. I will tell you that there are ways to change the Electoral College, one being, you guessed it, an amendment to the Constitution, which when we get to amending the Constitution, you'll see that it's quite difficult to do. But there are some other options that we'll talk about when we get to elections and campaigns. Okay, moving on. So the third article is about the judiciary branch. So let me just remind you, the first article is about legislative branch, the second article is about the executive branch, and the third article is about the judicial branch. You will be asked 2 or 3 questions on your exam about these articles, so you need to know those first 3 articles. Very important. They cover all 3 branches, but not in the order that you think. So legislative first, then president, then judicial. So the judicial branch is really short. I'm sorry, Article 3 is very short. It creates the Supreme Court and authorizes Congress to organize the other courts. So the Supreme Court doesn't have the power to create more courts. Congress does. So that's somewhat of a check and balance. Alexander Hamilton, at the time that they made the Constitution, said, oh, well, the Supreme Court, this should probably be the least dangerous branch of government, having neither the power of the purse, meaning they don't really have the power to create or use money, nor the power of the sword. They don't have a military at their disposal, where Congress and the president does have that power. So he predicted that Congress would be the least dangerous branch of government. This is in bold because you will be asked a question on this. And it's also kind of funny because the Supreme Court, as we will see through this court, does have a lot of power and is kind of, maybe in some people's eyes, not the least dangerous branch. Maybe at current times it could be dangerous because they have the power to change decisions throughout history, which we will see when we look at some landmark cases. The justices are selected by the president and approved by the Senate and have tenure for life. That means they can stay in their job for life. Now, just be clear, we're talking about federal judges, not Nevada state judges, federal judges. When we get to the judiciary branch, we'll talk about how Nevada elects their judges, but on the federal level, they are selected by the president. And we will also talk about this case, Marbury versus Madison, where in the ruling, the court actually gave themselves the ability to do something that wasn't written in the Constitution, to strike down acts of Congress, as unconstitutional or not. The fourth article talks about the relationship between the states, what they can and cannot do. A state can't start their own country. They can't start a different type of government. It has to be a democracy. And states may not discriminate against citizens of other states. So if a citizen comes from a different state, the rules have to apply the same to them as they do to everyone else in the state. Also, if each state must give full faith and credit to official acts of other states. So, for an example, if a same-sex couple married in a state where it is legal, or where it was legal, is legal, and they go to a state where that state decides they aren't going to marry same-sex couples, they still have to acknowledge and allow this couple to be a married couple because they have the state records from their other state where it was legal. So this is the clause in the Constitution that one of the clauses that the Supreme Court pointed to when they said that same-sex couples could, it was legal to, that states had to allow for same-sex couples to marry. Not within their state, but they had to recognize other states that did. Let's see. We'll get more into that later. All right. The Article 5, the amendments, talks about how they're going to amend the Constitution. There are two ways to do it, but for this class, we'll talk about this. 2 steps to this. There are 2 ways and 2 steps, but we'll just talk about one way, and that is 2/3 of the House and Senate must approve the amendment. And then 3/4 of the states must ratify it. And they can ratify it through either their state legislature or through a state convention. So please remember that. That's how we that's how we make an amendment to the Constitution. And then Article 6, Article 6 basically states that the Constitution, the federal Constitution, is the supreme law of the land. So if a state has certain laws, the federal law supersedes that law. It is the supreme law of the land. And then in Article 7, it talks about how to ratify the Constitution. It's just sets up how to ratify that they need a certain amount of people in the colonies, which they did. They signed it and ratified it. So our first Constitution only had these 7 articles in it. Ratification was a little difficult because the Anti-Federalists, they felt like they were getting stripped some of their control from their state rights. They felt that the president looked too much like a king, that maybe they gave him too many powers, that they were afraid of this standing army. There was a couple, and that the Constitution was missing a Bill of Rights. The Federalists, who were the people for the Constitution, felt they were 100% on board for passing the Constitution. It did pass by a very slim margin. But after it passed, then we went straight into amending it. The Anti Federalists insisted on adding the Bill of Rights to the Constitution, so the first 10 amendments are known as the Bill of Rights. It sets out our rights and our liberties, rights of the accused, and we'll go into those in a moment. And then after that, there have been 17 additional amendments from that time until the most recent one, which I believe was about Congress being able to raise their salary. A lot have been proposed. A lot of amendments to the Constitution have been proposed. The most often proposed amendment is to demand that Congress pass only balanced budgets. In other words, every 2 years when they pass their budget, they cannot have a deficit. They can't spend more than they plan on coming in. They have to have a budget that only spends the money that comes in. That has not passed as an amendment to the Constitution, and that is not in effect. So every 2 years when Congress passes their budget, they always spend more than they have coming in. We'll talk about that too. The second most common proposal for an amendment is campaign finance, so trying to get money out of the elections. We'll talk about that later. The third is term limits, putting term limits on Congress. Now remember, these are all amendments that need to be passed by Congress, so a lot of them don't want to have term limits because they like their job. They don't want to be out in 8 to 12 years. Another popular amendment that's been floating around is making it illegal to burn the flag, direct election of the president, so getting rid of the Electoral College. The Equal Rights Amendment has been around for many, many decades. We'll talk about that later. School prayer, I think that's allowing school prayer. And then also no same-sex marriage. Those are also proposals that have been floating around since 1999. Lastly, on the Constitution, there are 2 terms, originalism and pragmatism, that you need to read about in your book. Originalism is the way that you look at the Constitution, and it's that Americans are bound to the literal meaning of the Constitution and its amendments as the people who wrote and ratified understood them. So thinking about how the framers were thinking and what they meant, and we have to go literally by that. Pragmatism looks at the Constitution more as an evolving Constitution, and that we cannot help but bring our own background and ideas and judgments that we feel and know today as we think about the meaning of this document. So just read up on these 2 definitions. You'll have a question on the exam. See how you look at the Constitution. Maybe a little bit of both. All right, and there's a crash course little video there that can just kind of sink in everything we just went over. I know I'm going fairly quickly, but I'd like to keep my videos as short as possible. Okay, so the second part is the Nevada Constitution. The Nevada Constitution started in 1864, right around the time of the Civil War. There were, if you read your readings, we have 3 nicknames for Nevada. The Silver State, because of the Comstock lode that was found here. We've got lots of silver mining in the state. that brought people to this, drew people to the state to mine silver. We were also called the Battle-Born State because we were born in the midst of the Civil War and around the re-election of Abraham Lincoln. And we've also been called the Sagebrush State because due to our land disputes in the 70s and 80s, some of them over Yucca Mountain, the atomic test site, and Nellis Air Force Base. All right, this you definitely need to know. These are the conditions for which we became a state, conditions for us joining the Union in 1864. The federal government said, okay, Nevada, we'd like you to become a state, but we need you to promise us three things. One is to renounce slavery, because all of the western states now, as they were adding to the Union, they were renouncing slavery as they were coming in. This is pre-Civil War, pre-abolition of slavery. So they said you need to renounce slavery, and we put it in the preamble of the Constitution. The second is that the boundaries of Nevada hadn't been set yet, and so we were kind of intermixed with what is now Utah. There was a large Mormon presence, and so the federal government said you must constitutionally commit to religious tolerance. They feared that it would become a Mormon state, or that there would become a state religion, and that was against the U.S. Constitution. So they needed them to commit to religious tolerance, that any religion or no religion could exist within the state. And then finally, they had to cede all unclaimed territory, give up all unclaimed territory to the federal government. Nevada, about 87% of the land is owned by the Bureau of Land Management, which is a federal bureaucracy, and other government holdings. So we're a very large state. We have lots of land, but a lot of it is federally owned. That's where Yucca Mountain is. That's where Nellis Air Force Base is, the atomic test site. If we compare the U.S. Constitution to the Nevada Constitution, there are some differences in length. The U.S. Constitution is much shorter. Nevada Constitution, 56,000 words. It was the longest and most costly telegraph. They wanted Nevada to become the state before the re-election of Abraham Lincoln because he was hoping for their votes, and so they telegraphed the Constitution. And so it, if you can just imagine how long it took for them to write out 56,000 words. Also, the amount of amendments, the U.S. have far fewer. Nevada has over 130, I think closer to 140 by now. And this is because it's easier to amend the Nevada Constitution than the U.S. Constitution. There we are. Easier to amend. You only need a simple majority. The Constitution includes the Declaration of Rights right up in front, whereas the U.S. Constitution was an afterthought. A couple years later, the first 10 amendments were added on. The Nevada Constitution also includes issues like education and gaming regulations. We do not have anything about education or gaming regulations in the U.S. Constitution. And Nevada is also strong supporters of property rights. Now, similarities, the structure is a lot like the U.S. Constitution. The division of powers between the three branches of government is similar. The checks and balances are almost identical, and the establishment of the basic structure of Nevada's government is the same as the federal government. Excuse me. Again, the Declaration of Rights are right at the top. They give a greater protection of rights than the U.S. Constitution, and Nevada also has several ways for direct democracy. We'll talk about those in a minute. This is kind of an interesting, it's called the Madisonian dilemma that it talks about in your readings. And Madison said it is nearly impossible to protect the right of the majority to govern, like giving them the right to make decisions, 51% make a decision, while at the same time protecting the minority from tyranny of the majority. And when we're talking about minority here, again, I'm not talking about racial minority. I'm talking about numbers, the minority as far as a vote. If 51% agree that women can't work, then the 49% are out of luck. Unless the solution is that we have a constitution that contains protections of individual rights. So if individual rights are that everyone has a right to work, then this majority of 51% cannot vote and say that women don't have the right to work because it's within the individual rights. So a majority can govern, but only within specified constraints. So it's a little deep thinking to understand that, but we'll talk more about this when we talk about civil liberties and civil rights. This is the link of where the Nevada Constitution is. You can take a peek. Lucky for you. You can click on any of these topics and it'll go straight to, so if we go to the Declaration of Rights here, there's like 23 of them. You can go all the way down. Any of the amendments are just put right into the text. But lucky for you, I'm not asking you to read the Nevada Constitution because, well, look how long it is. But you're welcome to look there and see if you have a topic that you're interested in and see what it says in the Constitution. All right. Okay, some unique things to Nevada. Gambling and education are mentioned in the state constitution. Education must be funded before any other budget item. I always get quizzical looks from my students when I say that, this is in the Constitution. It doesn't say education must be funded well or must be funded enough. They just have to get to that first before they talk about anything else. So it's a gesture towards education is important. But as most of you probably know, Nevada has very low education test scores and also the lowest amount of funding towards education. So we'll look at that a little bit later in the course, how much should be funded and how much is actually being funded. And, there is debate about whether it's all about the money or the way we teach or the content or the parents. There's lots of different components of why education isn't, why we're so low in the, compared to the rest of the states. All right, prostitution is not in the Constitution, but has been left to the counties with one restriction. Prostitution is not legal in counties with populations greater than 400,000 people. So Clark County and Washoe County are not allowed. They have too large of population. All right. Oh, there it is again in there. Let me take this out. These are quiz questions that when I'm in a normal face-to-face class, but you can stop it and see if you know the answers. Otherwise, we'll continue on to look at these 3 direct democracy tools that Nevadans have that we're able to use in order to have direct democracy. We're like hands-on. We can put together an initiative and get it on the ballot. We can put together a referendum. There are steps that we have to follow, or we can put together a recall and get someone out of office. So an initiative, you need 10% of the signatures of the votes casted in the previous election. It has to be one subject. So you can't have 2 different items. It has to be either marijuana or solar energy. The legislature can approve it and then it's done, or they can reject it and it can go on the ballot. The legislature can also propose a countermeasure. So if they see the citizens trying to put something in and the legislature thinks, oh, that's great, but it's not good enough, so then they can propose a countermeasure and put another initiative on the ballot. So sometimes you'll have 2 initiatives that sound like each other, but are a little bit different. For a constitutional amendment, which is also an initiative, it needs to go on the ballot 2 years in a row. So we saw that with the energy initiative, which was about removing the monopoly from NV Energy. It passed the first time it was on the ballot and failed the second time. So that gave 2 years for the citizens to do their research and be swayed by interest groups to change their mind one way or the other. And then also, it has to show monetary appropriations. It has to show how it's going to be paid for. So you can't just put any initiative on the ballot and not give how you're going to pay for it. So it has to either be a tax or some way to pay for whatever you're proposing. That's an initiative. A referendum is an attempt to void a law that has already been passed, to void or approve. So if there's a law in the books that the citizens want to show their support for, then they'll ask to put a referendum on the ballot, and you'll just vote yes or no for it. If there's something that has been passed by the legislature that they don't like, they can put that on the ballot as a referendum, and they can vote against it, and then it's taken off the books. A recall is removing an official from office, and depending on whether it's a state official or executive official like the governor, lieutenant governor, secretary of state, they have to be in office 6 months before you can recall them. But for the Senate and Assembly, they only need to be in office 10 days, and that is because they have a very short session period. It's only a couple months in the first part of the first year that they're in office, and so that just makes sense that they should be able to be recalled right away and get someone new into their office. There's procedures that take place. You have to get signatures. They have to be approved. And for this signatures, it has to be people that actually voted in their district. And you can't get people that just moved there either, or that chose not to vote. So this is a little bit harder to do a recall. Okay, some fun tax facts that you never thought you'd hear fun and tax in the same sentence. Nevada does not allow income tax, lotteries, tax on lotteries, they just don't allow lotteries, inheritance tax, or any tax for religious purposes or food. 80% of slot machine tax is earmarked for education. Still not enough, but that's where some of the money comes from. Property taxes have a cap. You can read more about that in your reader. And Nevada does tax liquor, cigarettes, marijuana, tobacco, insurance premiums, jet fuel, hotel, motel, room rents. I think they have entertainment taxes, diesel fuel, and probably a bunch of other ways to get some kind of income revenue, since we do not have income tax, which is a big portion of other states' income. So constitutions, if it's in the Constitution, it's considered constitutional law. Statutory law is law that is created by the legislature. Some law can be expressed or implied. The Nevada Constitution is more explicit regarding the rights and separation of church and state. So it's a little more progressive, but on the other hand, it took us quite a long time to legalize same-sex marriage, till 2014, and then the landmark court case was just a year later anyway. So there you have it. In conclusion, Nevada is a highly individualistic and libertarian state. Majority rules is dominant. We have the direct democracy and simple majorities. There are many civil liberties and civil rights in the Constitution, although these could be changed by a simple majority, so it's not always a guarantee we can change the Constitution. Taxes need a supermajority, so taxes are where we draw the line. If you're going to raise taxes, you got to have a lot of people, 2/3 of the vote in both chambers. Nevada has historic economic opportunities. Okay, so hopefully this will be the longest session. I'm trying to keep mine rather short, within an hour's time or less. But your exam notes for these two U.S. and Nevada Constitution. First, for the U.S. Constitution, you need to know and understand the following topics. Know and understand what the Declaration of Independence is, Article of Confederation, and the Constitution, as well as the Nevada Constitution. Know about the arguments shaping the Constitution, especially these two items. Who do citizens vote for before the amendments? Like which office did we vote for? Did we vote for House of Representatives, Senator, and President right off the bat, or just the House of Representatives? Yeah, so you need to know that. Also, the dilemma, the challenge, and the compromise between representation, big states and small states. So please read that in your chapter. Listen to the lecture and review the slides to understand about the Virginia plan, the New Jersey plan, and the Connecticut compromise, and be able to explain that in your own words. That will be an essay question. You should know what checks and balances and separation of powers are. There's the triangle example. You can look in your book and reread that part. You should understand the Electoral College, although we will be talking about the Electoral College throughout the course. You should understand the three parts in the Constitution about slavery. You should know the first three articles are about the three branches of government, and you should also know what's in Article 1, Section 8, and understand the terminology of originalism and pragmatism. Then for Nevada, you should know the three conditions for statehood, the differences between the US and Nevada Constitution. There's many um, differences and similarities. And then you should know about these three forms of direct democracy. Okay, great. Thanks, and see you next time.